Wait, okay, we're recording, great. So welcome everybody. Happy to see my familiar faces and welcome any new ones. Before we kind of dive into the protocols, Matt, did you have anything you wanted to say before we get going?
Well, just to thank you, Nadine, in particular, for continuing to chair so ably this committee. You've been doing this a long time, and we very much appreciate it. I'd also like to thank everybody for joining, all our members for joining us for this, I guess, our inaugural committee meeting for the fall semester 2021. And then finally, I would just like to recognize and thank very much Jeremy and Mark for writing an outstanding report, and Jeremy, I think, for doing, as he often does, multiple jobs, which is writing the report, serving as his own supervisor, and also staffing the committee proceedings. I guess along with Mark too. I shouldn't slight Mark here, but anyway, thank you for the great report. And one just comment largely for Jeremy's benefit. This is the and Mark's too. This is one of two recommendation projects we have this fall that returns to ACUS recommendations from the 1970s, albeit under very different circumstances. And I hope Jeremy or Mark, who's ever giving the initial presentation, will say something about our earlier recommendation on the subject of public access to adjudicative proceedings. So with that, I'll turn it back over to you, Nadine.
Thanks, Matt. Yeah, we have two wonderful consultants, ACUS staff, to guide us through this with a wonderful report. So before we dive into the subject matter at hand, I have to read the script. So bear with me as I read the script, which I forgot about, and Jeremy helpfully reminded me.
I think I forgot to read roll at the very beginning, Nadine. So
oh gosh, I'm just jumping
that is
ahead.
my fault. If I can just interject real quick and just call roll real quick for our committee members. So when I say your name, please just unmute yourself. Say here, just to make sure your microphone is working and we can hear you. Nadine, you're obviously here and we can hear you. Kent Barnett.
I'm here.
Jack Bierman. Eric Benderson. Michael Cole, Anika Cooper, Claire Evans.
I'm here.
Hi, I see you there. Susan Grunman, Janice Hoffman, Renee Landers, Tristan, see you there. Bob Lesnick, Jeff Lubbers.
Here.
Judge Emanuel can't join us today. Tom McCarthy, I think, is joining us a little later. Melissa McIntosh. Patrick Nagel. His alternate will be joining momentarily. Just got a request for Zoom info. Roxanne Rothschild.
I'm here.
Bob Schiff, John Vitone, Chris Walker,
Here.
Melissa Wasserman is joining us a little later, David Welch, and Russell Wheeler. I think it's the usual audio issue. Great. Did I miss anyone?
This is Anika Cooper. I joined after you started, I think.
Great. And Dan Ho, I see you're here as well. Perfect.
I'm here.
Great. Besides the committee, Bill Funk, I see you're here and I've heard you.
Yep.
And that should do it. Thanks, Nadine.
Can you hear me now, Jeremy?
Yes, that's perfect.
Okay.
Wonderful. All right.
You're muted, Nadine.
See, Mark, I jinxed myself. Said I wasn't going to do that.
It's my fault for jinxing you.
Okay, start over. As many of you already know, only ACUS members, government members, public members, senior fellows, liaison representatives, and special counsels, whether or not you are on this committee, and your designated alternates have full speaking privileges. To avoid background noise, please keep your microphone on mute. I will try not to follow this rule. And use either the hand raise function, which hopefully everybody knows by now how to use, or you can add a comment in the chat feature if you would like to speak. I will call on you and you can unmute yourself. I'll give you time to do that, and then remute yourself when you're done speaking. Please do not put anything other than I would like to speak in the chat. We don't want any substantive content in the chat function. Also would ask that ACUS members and their alternates use the webcam to facilitate conversation. I know from all of our Zoom meetings over the past year and a half, this is a great way to just connect and see people. So respect to any other attendees other than the ACUS members and alternates. To participate, you must have unanimous consent of the committee members. Time permitting, I will consider calling on such attendees at appropriate points. And we will presume that committee members consent absent raising an objection. If any participant would like to speak, please indicate again in the chat feature or use your hand raise function, and I will call on you and wait until I call on you to speak, and then you can unmute and remute when you're done. For all participants, again, don't use the chat function for anything other than I would like to speak. Only members of the adjudication committee, the category I mentioned earlier, have a vote. We probably won't be voting today, but my goal is by next meeting we will vote. Please do not vote unless you're a member of the committee, and Jeremy and I will keep everybody honest on that. We have a list in case you're not sure of your status. Anything else, Jeremy, that I missed?
That should be it.
Okay. All right. Now I will turn this over to Jeremy.
Great. Thank you,
Talk
Nadine.
about the report.
Thank you, Nadine. I will speak for myself and Mark. We both worked on this project together. I'll present today's remarks, but Mark, feel free to jump in if you want to add anything. So a couple of years ago, this committee considered a project on independent research by agency adjudicators in the internet age. It was a fairly ancient question. When is it appropriate for decision makers to do their own research outside the records supplied by the parties? That took on new salience in a rapidly changing technological environment. Alan Morrison, I think it was, called it a case of old wine in new bottles, the plenary. That's been a consistent theme for the committee over the last few years, and this project, Public Access to Agency Adjudicative Proceedings, is no exception. You'll recall the committee began to discuss public access in the context of virtual hearings just this past spring. Questions raised in the context of that conversation led to this project. In the course of our research, we were struck by how often ACUS has tackled questions of public access to agency adjudicative proceedings. ACUS's very first recommendation back in 1968 was simply titled Adequate Hearing Facilities. It recommended that GSA develop a set of 4 hearing room classifications that varied primarily in the amount of spectators they could hold. 2 years later, recommendation 71-6 tackled public participation in administrative hearings, including on-the-record adjudication, and dealt with questions like access to advance public notice and transcripts. A year after that, ACUS tackled the issue of cameras in the courtroom in recommendation 72-1, broadcasting agency proceedings. This committee has already discussed public access at least 3 times in the past few years for evidentiary hearings not required by the APA, agency appellate systems, and virtual hearings earlier this year. What ACUS hasn't done yet, so far as we can tell, is step back and take a comprehensive look at when when members of the public can observe proceedings that agencies conduct in the course of adjudicating cases, and how agencies operationalize public access to open proceedings. These aren't new questions, but they have, again, taken on new salience in a changing technological environment. The internet provides new ways for interested members of the public to observe proceedings. It was easy enough to say no cameras in the courtroom a generation ago than it is today. And agencies can leverage e-government to better provide advance notice of proceedings and access to recordings and transcripts. Public access can serve any number of objectives. Openness can serve the interests of parties and agencies alike, ensuring fair treatment and the availability of emotional support for parties, and accurate and efficient record development for parties and agencies alike. Openness also serves important public purposes too, especially transparency and public knowledge of agency decision-making and current events, and facilitates public participation in programs that feature it. But openness can also have its drawbacks, revealing sensitive information, exposing witnesses to intimidation, encouraging adversarial postures rather than consensus, etc. Of course, objectives of public access and drawbacks from public disclosure will vary across programs and agencies. Public access may serve very different purposes in, say, FERC proceedings, which deal with issues of broad public interest, than in Social Security disability hearings, which rarely do. Throughout our research, we were struck by the need for agencies to identify the objectives that public access serves in the programs they administer, and to craft their rules and policies accordingly. This project and our report proceeds in two parts. The first addresses what we've called doctrinal openness. That is, when are proceedings open or closed as a matter of constitutional principle, statutory requirement, or agency rule. Mark undertook an analysis of the First Amendment case law in this area. Suffice it to say, courts have sometimes found the First Amendment right of public access to adjudicative proceedings and sometimes not. Agencies will need to be attuned to that still developing body of law and the principles and norms it represents. We scoured the US Code and Code of Federal Regulations for relevant requirements in an attempt to identify patterns for which kinds of proceedings and which programs at which agencies are presumptively open to the public and which are presumptively closed. We were also interested in the conditions that warranted departing from those presumptions in particular cases. That is, when do adjudicators close proceedings that would otherwise be open to public observation? And when do they open proceedings that would otherwise be closed? The recommendation as drafted distills our findings. The second part of our inquiry dealt with what we call functional openness. That is, once an agency has determined that a proceeding should be open to the public, how does it facilitate public access to that proceeding? We looked at in-person and remote access, including many of the questions this committee asked during last spring's discussion of virtual hearings, including technological issues and issues of access to justice. We also looked at ways agencies can provide advanced public notice, disclose transcripts and recordings, and publicly communicate relevant rules and policies, but also plain language instructions to help members of the public really understand what public access is, their role in it, and how it works. The recommendation as drafted distills our findings on these points as well. I'll just close by thanking the interviewees who took the time to speak with us and share their expertise, and with the many of you who have already shared your comments with us. We look forward to today's discussion.
Thanks, Jeremy. Before we turn to the recommendation, I always give some time if there's any general comments about the report itself. Any discussion or comments? Jeff Lovers. How are you, Jeff?
Hi, Nadine. First I want to say I think it's a great report, really well researched and readable and accessible. No pun intended. But I did notice one thing that you didn't talk about. You mentioned, of course, the Freedom of Information Act and the Government and the Sunshine Act, but you didn't mention the Federal Advisory Committee Act. And I thought that was a little curious, since there are a couple of things in that act that I think might be relevant to this recommendation. One of them is, of course, if the committees under the Federal Advisory Committee Act are under some obligations to provide information, copies of things that they're considering during their meetings to anyone who's attending the meetings. I'm not necessarily recommending that we add that to the recommendation, but it does seem relevant to the discussion in the report. But there's also a provision in section 11 of FACA, which has to do with availability of transcripts. And it's not just for transcripts of advisory committee meetings. It says that except where prohibited by contractual agreements entered into prior to the effective date of this act, agencies and advisory committees shall make available to any person at actual cost of duplication copies of transcripts of agency proceedings or advisory committee meetings. And then it says agency proceedings means any proceeding as defined in section 551.12 of Title V, and that includes rulemaking and adjudications and everything. So if that provision, I don't know if it's ever been interpreted or litigated, but it seems to require that any transcript has to be made available at cost, not under the FOIA rules as you suggest in the report.
Thank you.
Any other comments? Jack, good to see you.
Hi, nice to see everybody. My sort of overarching comment was, I mean, I agree with what Jeff said. The report is great. The recommendations seem very sensible and well written. I was really pleased to see what you guys have done with this. But one thing that kept creeping up on me was in reference to these other statutes, like the Government and the Sunshine Act and the Privacy Act and FOIA. How much did you? I'm just curious. How much you coordinated your sort of exceptions ideas? Times when you would keep things closed, and times where transcripts and such might not be accessible. How much did you try to coordinate with the sorts of exceptions that there are in FOIA and in the Government and the Sunshine Act and in the provisions of the Privacy Act? Because it seemed to me that it would make sense to sort of parallel those as much as possible, rather than try to reinvent the wheel about when things ought to be kept confidential. We could take guidance from those pre-existing provisions, at least as much as possible if they fit. So I think that's a general comment, not something on any particular provision.
Yeah, I can say as a general point, the conditions that are listed in that specific paragraph dealing with when proceedings can be closed are based heavily on what the committee came up with in 2016-4 and in 2021 for virtual hearings. So we largely tracked that language with a couple of slight variations to, I think, better reflect some of those circumstances, but that's a point well taken.
Any other comments? Hi.
Just one brief comment, and I'm thinking about this with my hat as now one of the co-chairs of the implementation advisory group. Like, how do we make sure that what we do here is then used? And one of the things is to make it very accessible. And I agree. I mean, the report, very clear, the recommendations, very clear, but for some busy agency staff, it's still going to probably be too much. So as we're going through, I think one of the ways to make it accessible is to take just 3 or 4 examples of an actual proceeding and say, here's how we would apply all these factors, because that's so much of what we do, consider these factors. So it would be something we would do towards the end of the process, not the beginning, but I just, as a general point, wanted to raise it as one approach for making these recommendations easier for agencies to implement.
Thank you. I think that's something to think about. I don't know if that's something we've typically done. I don't know, appendix popped into mind.
We definitely haven't typically done that, which is why, just even in my first conversation with the other 2 co-chairs about what can we start thinking to build into the process from the get-go that we haven't really done. And again, so I'm just offering it. We might be a little bit of a case study here in this committee. Like I said, it's not what we usually have done, and it's not necessarily our greatest expertise, but some of the folks, of the government members, do have that expertise. So at some point in this process, so.
Okay.
It could be added to the report as an appendix, once we finish the recommendation.
Yeah, appendix.
Good idea.
Mm-hmm.
And then we could cite to it in, Okay, anything else? Any other comments, thoughts, questions? Okay, great. So we have the recommendations. We do not have a preamble. Sometimes that works that way. I think sometimes how we shake out the recommendations informs how the preamble turns out. So everybody should have the recommendations that were circulated by Jeremy. I think it was Jeremy who circulated, or Mark, both. And we'll just start right at the top. If there's anything, thank you, Mark, for posting them up. Now I'm losing everybody. I think I can see.
I was going to say, please blow it up. That's perfect.
I want to be able to see. No, that's not going to work. Sorry, I am trying to figure out how I can see this chat. I might not be able to.
I think when you just sort of move your cursor down, it'll appear again. As
There it
opposed
is.
to,
Okay,
yeah.
there we go. Thank you for the tech support. So we'll just start right off the top. Obviously, the opening recommendation just kind of lays out the objectives of the reason we're here. So any thoughts on the first recommendation?
Yeah, Nadine, this is Russell.
Hi, Russell. Yes.
I circulated, but much too late, a few comments. But one suggestion at the very first line, the objectives of public access seems to suggest that agencies should be developing generic descriptions of objectives for all agencies. I think we mean to say the objectives of public access to their adjudicative proceedings. And on line 8, basically the same point. In other words, we're not calling on agencies to issue general policies, but to specify public access to their proceedings alone. Unless I'm misreading the purpose of the recommendation. And if so, obviously I recede.
No, that's exactly what we intended.
Makes sense to me.
So that would be on line 7 and then line 8 to their adjudicative proceedings. And I would suggest at line 10 to say before adjudicative, the agency's adjudicative proceedings. And then the only other suggestion is on line 12. The reference to any circumstances in which adjudicators may or must depart from any circumstances could be, page after page. If you're thinking of individual circumstances, perhaps something a little more generic, some kind of more generic wording. I didn't come up with anything, but circumstances which, major circumstances or something like that. So we're not calling on the agencies to identify every little eventuality that might come up, unless, again, I'm misreading the recommendation. And I defer to the authors on that one as well.
No, I don't think we intended to have, hundreds of pages of examples of when proceedings could be closed. We're talking about general circumstances like those reflected further down in the recommendation.
You might just strike the word any. I mean, I think it's sort of implied,
Right.
And circumstances in which adjudicators, that doesn't mean that you're going to list every one of them, but it means you'll be rather specific. And, I think any agency could imagine the major items that would fall under that.
Thank you. Bill. Unmute.
Down here. Okay. All right. I read this, and I read all of it from the perspective of having been a government attorney and trying to figure out when the general counsel hands this off to me and says, respond to this. And I was trying to figure out what would be the objectives of public access to the adjudicative proceedings in our agency? And, other than saying, well, good government, transparency, I mean, I'm just not sure how you respond to these objectives. And I haven't made it all the way through the report, but I made it through the parts that I thought would sort of maybe give me a hint what the objectives might be for a particular agency, but I didn't get it. Am I missing something here in terms of something that's more specific than good government and openness?
I think, yes, from our perspective. You certainly have very different kinds of proceedings conducted by agencies across the federal government. Some of them involve pro se claimants applying for benefits, no representation. They bring a family member or a friend with them for a source of emotional support. That is obviously very different than an FCC proceeding, say, involving a large corporation. So
I understand that. I understand that. The question is, for proceedings that we might presume would be public, all right? The question is, what do you mean by the objectives of the public access? Because it doesn't say identify which of your proceedings should be public. It says what are the objectives for it?
Public access has been interpreted as benefiting parties, agencies, and members of the public who are neither parties nor agencies. That plays out differently in different schemes. In some areas, public access is primarily a benefit to the parties, ensuring the parties have eyes on the agency proceeding to ensure a fair proceeding. In some cases, it's more about legitimating an agency process. In other cases, it's more about reporting on newsworthy events. In our interviews with adjudicators across different agencies and with experts outside the government, there were very different rationales provided for public access, depending on the scheme.
Jeff, did you have a comment on this?
I'm still trying to figure out. You talked about rationales for public access, but it's identify objectives of public access, and again, I'm just not. What is the agency trying to achieve by providing public access? That's what I would view objectives as being.
I don't know who came in first. I'm going to turn to Matt first, and then I'll go to Jeff. Matt.
I would just recommend to the committee that it seriously consider if this paragraph is going to be retained and we're going to refer to objectives, there needs to be some explanation in the recommendation itself as to what kind of objectives we're talking about here. And that should not simply be left to the preamble, because what will happen is with our council or at the plenary session, somebody is going to suggest and may prevail on others to modify this to provide to specify what objectives we're talking about. It's put more simply, I think it's too vague.
Okay, Jeff, go ahead, Jeff.
Yeah, I think this conversation's highlighted an issue that I didn't notice before, which is that we don't really say, maybe this was going to be in the preamble, but we don't really say what our position is in terms of, how we feel about public access. I mean, I think rather than give the agencies a task of trying to draft objectives, why don't we just say that agencies should not maximize necessarily, but optimize, the public access to adjudicative proceedings, bearing in mind the need to close sometimes. I mean, we need a sort of an opening paragraph that urges agencies to sort of take a proactive position in favor of access.
Yeah, I think Mark has pulled up. I mean, there is that presumption in recommendation 5, and I think that's consistent with prior ACUS recommendations that there's a presumption of open proceedings.
Maybe that should begin with something like that.
And I'll just add, I mean, I actually wrote in my notes and going over this whether we even needed to include one. I hear what Matt is saying. I just think it will invite discourse, and whether we just confine that to the preamble and just dive right in.
There's just, Nadine, I mean, with the sort of persistent problem here, the recurring problem is that there's always a demand that the recommendations stand on their own without independent, that is, of the preamble. And this would be, I think, a very clear example of a situation in which that might be flagged as a problem.
Hi.
I want to endorse your suggestion, Nadine, that I think the way to do this is not to have recommendation 1, and recommendation 1 is policies for public access, you know. And I think for that, we can see as we go through whether at some point we want to start with flipping it and say, here's what we think the presumption should be, or still start with agencies should promulgate and publish their procedural regulations governing public access. And this is what it should cover. And then the next being our presumption. I think that we can decide afterwards, but I want to endorse your idea of deletion of number 1.
Any other thoughts on that? I mean, I guess I assumed that the premise here was that having an open proceeding, we think, or ACUS thinks, is a good thing. So you start there. And to the extent there are reasons not to do it, we'll tell you, the recommendations will explain some of the things you should think about. Jack.
My usual quick drafting on the fly aptitude seems to have escaped me today, but I would recommend maybe adding a sentence after the. I'm on board with deleting number 1, but I think maybe adding a sentence after the first sentence of number 2, which made the point about the word optimize. I'm not sure that works, but in formulating these regulations, something about formulating the regulations, they should consider the consider the purposes of public access, and something about the countervailing interests of privacy and confidentiality as elaborated below, something like that. Something general like that, to say obviously they don't really need, obviously anyone who's promulgating regulations is thinking about the policies underlying them, but it seems like maybe that's what number 1 was trying to do, and maybe putting it in there would be helpful, something like that.
Roxanne, how are you?
I was thinking about something very similar to what Jack was saying, which I was thinking in the exact same spot. If number 2 becomes number 1 after the first sentence, maybe the next sentence could be in formulating these regulations, as Jack said. And I was thinking more along the lines of including then the part about the constitutional requirements and applicable statutory requirements. So basically saying, whereas he said the second sentence would be mindful of the needs or the objectives, I was thinking you could say, in formulating these regulations, agencies should be attentive to constitutional requirements for public access and any applicable statutory requirements. Basically, the second part of that second sentence in number 1, so we don't lose that part of number 1, and just incorporate it in number 2 in that way.
Thank you. Any other thoughts on, I guess it's 2 things, deleting recommendation 1 and revising what would become recommendation 1. All right, we'll delete 1. It'll still be there in a bubble, I think, if we decide we want to go back. Thoughts on now, what is now recommendation 1 in terms of the revisions suggested by Jack and Roxanne. Roxanne?
Or it could be just one horribly long sentence that incorporates both. Basically says, be mindful to comply with the law and think about what purposes it serves. I mean, something along that lines.
Bill?
Just in editing, but in terms of the new second sentence here, in formulating these regulations, agencies should be attentive to any constitutional or statutory requirements for public access. Any constitutional or statutory requirements for public access, and then that makes it a little bit shorter.
That's great. And consider, should we try Roxanne?
Yeah, I think that's good. I think, and consider.
Sorry, I should explain. I had the text of both suggestions up there so people could compare.
That's great, Mark. So we've got the first clause, I think, nailed down, and consider the purposes of public access. I know Jack was kind of spinning this off the top of his head. Any other kind of thoughts on that second clause? Jeff?
Rather than purposes, the benefits.
Any other thoughts on that clause? Hearing no further thoughts, we could leave that one. Okay. So anything on the third line, and then we'll get into our list. I struggled a little bit with all significant matters. I wondered if we should just say these regulations should include the following.
That would make sense to me.
I agree.
Okay. Jeff, did you have your hand raised from before? Or are you ready to suggest any? Okay, good. So let's go to A through D. Any thoughts on A through D? Bill?
What? Oh, I'm sorry.
Oh, that's okay.
Because when I thought this, when you're getting the regulations, I thought the regulations would actually identify which adjudications would be open. Not just the standards for deciding which ones are presumptively open, but which ones would actually be open and which ones might not be open depending on certain circumstances that might arise in the particular proceeding. Shouldn't the regulations be specifying which adjudications are presumptively open rather than just providing standards?
Thoughts on that, Russell? Were you?
No, that's, I'll waive any comment.
Okay. Hi.
I actually like that concept. I'm not exactly sure how it would go, but I think it is important to have them both list the ones that will be presumptively open or closed and the standards that they use to determine that. So it could be still standards for determining, and then B, based on those standards, you know, you get what I'm saying. You know what I mean? It's standards for determining a B, based on those standards, which agency it is standards for determining which proceedings are presumptively open or closed to public observation, and the agency proceedings that will be either presumptively open or closed. And then B, or not even B, I don't know how you do that. As well as circumstances in which adjudicators may or must depart. May or must depart. Oh, that's interesting. But there's also a must. I mean, that's not the best drafting, but I'm just putting in the point of, we do want the regs to say, and these are the procedures.
Jack, did you?
Yeah, I have something just generally on a question about this, which is, is there a reason why we need standards for determining which proceedings are presumptively open, rather than just a list of which proceedings are presumptively open and then standards for determining when particular proceedings might end up being closed? That's what, I'm just wondering about having standards like meta standards to determine then which in the variety of proceedings are open. I'm not sure about that. It seems a little uncommon to me to have standards for making, as opposed to just listing them.
Fine.
What I like about the standards point, again, I'm sort of thinking practically in terms of implementation, they're not going to come back to like redoing the regs. If someone has spent some time figuring out what would be the rationale for presumptively open or closed, you know, 15 years later, when there's some other proceeding, the agency would have that as a sort of starting point. Again, I'd be curious in terms of, you know, the drafters, what they thought in terms of the utility of that, but that's what I could see as you, and I actually think it could be pretty straightforward and simple, you know, what the standards are, back to the very first point of sort of not a lot of rocket science reasons for why we want this, but that to me would be the utility of it. But I would be glad to hear from the people who drafted why they thought that'd be useful.
No, actually listening to your conversation, I think, Bill, I completely agree with you. I think that's the simplest and most elegant way to do it, is just list the proceedings that are presumptively open and which are closed. I mean, obviously there should be guiding principles behind it. I think our thinking was that when you're drafting it, you should think through why are certain proceedings open and why are other ones closed. But in terms of providing useful information to the public, it is simpler to just list proceedings which are open and which are closed.
Jeremy, would these be, are we talking about, would you contemplate that some proceedings should, and the rules should reflect that they're categorically open, and some presumptively open, or are we always talking about presumptively open? Presumptively such that there might be considerations that outweigh the presumption.
Yeah, it's difficult because when we're talking about closing proceedings, in some cases we're talking about enclosing entire proceedings, and in other cases we're talking about closing parts of proceedings. So in that sense, if there's a proceeding that's open 90% of the time but closed for 10% of the duration of that proceeding because there's some CBI discussed, you might call it a categorically open proceeding that's closed in part to protect certain information. You could say it should be categorically or presumptively open or closed. I mean, that would leave it up to agencies to determine whether there are cases in which they should just be categorically open. Probably covers it.
Bill?
Well, I'm glad we get the list, but now I think what we also need are the standards for why you might change the presumption in a particular case or as part of an adjudication. In other words, that's where you need the standards to guide the discretion of the agency in particular circumstances to close or open all or part of a particular proceeding. So the standards are important, but the standards are to aid the discretion to counter the presumptions we've already established for particular proceedings.
I do think that we get into those details. So we have, this section is the policies. The next section is the standards and procedures. So I'm wondering, are we really driving at blending those? Is that really what we're looking at here?
I think, Bill, what you're saying is a list of proceedings which should be categorically or presumptively open or closed, comma, and standards for determining when adjudicators may or must depart from that presumption in individual cases, or a presumption in individual cases.
Exactly.
Mark, go ahead.
Bill, if I can just ask for a comment to that, do you want that as the standards bit as part of sub A, or do you envision that as a separate, for example, a sub B here, and then do
Bill, Mark, it's hard to hear you. I didn't catch what you said, and he's directing the question to Bill. So yeah, Bill, if you.
Bill, I'm curious if you could, you envision, is what's up there fine now, or are you envisioning the bit about standards as a separate, like a sub B to this?
No, I'm really happy with the way it is there.
Jeff.
Yeah, I like the way it's worded too. I'm just wondering, maybe this is a question for the authors of the report, whether you feel confident providing any sort of standards or guidelines as to which types of proceedings should be presumptively open and closed, because your report does indicate that Social Security cases are presumptively closed. Inquisitorial ones tend to be closed. Independent regulatory agency enforcement proceedings tend to be presumptively open. I mean, is there a place in this recommendation where we could opine on this a little bit?
Isn't that recommendation number 5?
Yeah, paragraphs 5 and 6, I think, get at that, at least from my perspective.
Is everybody okay with A as drafted right now? Let's move to B then. I don't know if we need it ordinarily, but that's just me. Okay. Okay, yeah. C, B. I did have a note here on this one. I know it's really maybe more committee on style, but in some places we use the full open proceedings. So like in C, we just say proceedings, and in D, we just say proceedings. I don't know if we want to say open proceedings every time we want to mention that, or if it's just understood that we're talking about open proceedings. I just flagged that. Yeah, we have it in B, but not in C. But maybe it's understood referring back. So since we helpfully deleted one, now we get to renumber everything in our notes. We'll move to recommendation 2. I'll say I love the reference to plain language.
There was a judge. The judge suggested adding something to D, the previous one, right? He wanted to add audio and video recordings before recordings. Audio, I guess audio and video. He suggested.
Yeah, I'm not sure where would that go? Mark, I see you shaking your head. I'm not sure either.
I thought it was in the previous D, accessing transcripts and audio and video recordings of proceedings.
Oh. Thank you, John. Great.
Nadine, before we move to the next one, I had a quick comment on B.
Yes, go ahead.
So, in my experience, technology, changes faster than regulations do. And so I wonder for B, if this is going to be, a codified regulation, whether we should just suggest that information about the manner in which agencies can access this, these proceedings be made available, and it be clear, because the remote means that are going to be used might change significantly. Agencies might have different, headquarters when leases expire and that kind of thing, and you don't want to actually enshrine, specific addresses in there. That's something that our agency has had to, clean up and change by regulation, and it just takes longer to do that. And so I'm wondering whether we can specify not the exact remote means or the exact location, but rather require agents, or suggested agencies make it clear where the information can be found, because that may be information that's more appropriate to be in the procedural schedule for the actual decision, for the actual proceeding, or somewhere else.
Thanks. Roxanne?
Annika's comment dovetails nicely with something I was thinking about, which was we don't mention how agencies will tell the public that there are proceedings, and that's something our agency struggled with a bit, what's the best way to do it. But I think in terms of what Annika's saying, that could change over time depending on what the technology is, et cetera. So maybe if B could encompass not only where and how they can observe the proceedings, but where and how they learn the proceedings are even taking place. So I'm not quite sure how to phrase it. I apologize for not wordsmithing that in my brain before talking, but I think we could hopefully encompass all of that in the one.
So we would pull, because right now that's in C, right? The advanced.
Well, that's whether they need, yeah. So C could come in there too. So that's whether they need to register, but I was thinking just the topic of how do they even know it's taking place? Do we put it on?
No, I'm sorry, Roxanne. I was looking at C under recommendation 1.
Oh, I'm sorry. Okay.
I think Anika's comment was.
Go ahead.
Sorry, Anika's comment I think relates to B under recommendation 1 and the examples that we have there. Is that right?
Correct.
Okay. Oh, I'm sorry. I thought you were talking about.
No,
I've lost track.
Okay, that's okay. We went backwards. I should have flagged that.
So when we were discussing moving to remote hearings, we did talk about, what needs to be open, how open is open, where they can watch it, how are they going to watch it, how are we going to be making, it's one thing to say what are the requirements for advance notice, but also even just the bugaboo of figuring out how are you going to give that advance notice. I think is slightly different, but I think we don't have to, I think we could encompass that all together. Especially with the idea that Annika raises, which is that this is going to change over time. And people aren't going to keep wanting to change their rules to keep up with what's changing.
Jeff, you have a comment on this?
We haven't discussed something that I think might come up later in this project, which is what about people with disabilities, you know, hearing and sight, vision disabilities. That's kind of a manner in which the public can observe proceedings. And I think maybe we need to say something about that. Maybe Kai has some good ideas as to how to handle that.
Well, I actually also had raised my hand on the previous one. So I would say on the previous issue that Annika said, I actually think with some of these, we again should think about a little, you know, sort of checklist, you know, maybe in an appendix for agencies, alerting them to something like don't put in a specific location in the regulation, which they may not get if we just take out, which I think we can take out to Annika's point on B and number 1, by attending in person. I think you can take out at a specific location. And it can be, for example, by attending in person, e.g. at an agency office. And then in our little, you know, cheat sheet, you don't have to say in person. I think you can just say e.g. at an agency office. You don't need to do anything else. Yeah. Or by remote means. And then since they would anyway have as their background requirement, they would have to be providing reasonable accommodations. I'm not sure we need to say it here in the recommendation, but again, it's sort of, I mean, I've just been thinking about this checklist idea, you know, under the checklist, remember reasonable accommodations, you know, as opposed to us needing to put it in here. So I actually like that point, Jeff, but I'm not sure it needs to actually be in here since they'll have that requirement, whether we say it or not.
Put it in the preamble, mention it in the preamble.
Mention in the preamble, and this isn't an issue of, we shouldn't say something in the preamble that we need to say in the recommendation. We can say it in the preamble, it's just reminding them of their background requirement. And then in a way, if we have a checklist, that's where we might pull something from the preamble to make it user-friendly for them.
Russell.
Doesn't what used to be section 10 on page 5 cover some of those things as well?
Yeah, I do think a lot of these details that folks are raising are dealt with in the later sections. So, I mean, I read the recommendations as starting broad and then building details in later. I see Mark shaking his head. I got the message.
10 refers to participants who are likely to encounter barriers to accessing open adjudicative proceedings. It goes on and on. And I think there's Jeff's concern is well taken, but I think there's a place to deal with it. It's on the screen now.
Dan, hello, welcome.
Hello. Nancy, I agree with you entirely. I didn't, honestly, it took me a second read to understand the contemplated organization here, which is that the sub-bullets we're working on right now are really each of the following sections. So I just wonder whether what we could do here is to just flag that for a reader of the recommendation at the outset. It could be something like in lines 12 and 13, these regulations should, as spelled out in detail below, include the following. And then in each of the sub-bullets, A, B, C, we could have either a parenthetical or some cross-reference to the following sections. I think that would head off a lot of these finer points that are actually resolved later on in the recommendation.
Dan, you've articulated it way better than I could have. Thank you. Jeff, do you have your hand up for this or no? Okay. Any thoughts on that? I it's in line with what I was thinking, but I welcome any other.
I think it's a great idea.
So I will, just to go back to B, which I think Anika was trying to say, you can correct me if I'm wrong. Did you think we should take out the online telephone examples as possibly limiting down the line?
No, I think that if we're not going to suggest later that agencies in their regulations should specify exactly what those online mechanisms are, I think we're fine.
Okay, great. Okay, anything further C and D? We got, thank you, Jeff, for flagging the judge's edit for D. I think we're done with 1. Going once. Okay, back to 2. So now we're talking about guidelines, right? We started with standards, regulations. Now we're talking about guidelines in plain language.
Just a minor point on A, when suggests hours and minutes. I think we want to say which. Unless I'm misreading it.
Makes sense to me. Kent. Hi, Kent.
Hi, I'm probably missing something, but why is A still necessary based on our revisions to the noun number 1, which say to identify the adjudicative proceedings?
It's a great question. Anybody? Bill? Is there an answer, Bill?
Well, it's sort of. It seems to me that an awful lot of the new 2 is a repeat of what's in the new 1, not just in A, but in several of them, and that it's supposed to be in plain language. That's what distinguishes it from what's in paragraph 1. The regulation presumably is not in plain language. The guidelines will be. So if you can't figure out what the regulations say, here's the guidelines. So, I mean, I didn't see any problem with just repeating it in guidelines. It seemed to me that the regulations didn't have to be on the web page unless it's an agency already has all of its regulations on the web page. The guidelines on the web page would seem to me to make, and then they would, in fact, you'd want to have them essentially repeat everything in the regulations and have that on the website. That made a certain amount of sense to me. So that's the way I read it.
There's some new things in the guidelines, decorum and contact person and things like that.
There's some new stuff, but it's I think largely repetitive.
No, I mean, I guess, Bill, you make a great point that it almost seems like if you couldn't figure out the regulations, here are the guidelines that are going to explain this exact same point in plain language, which is a little troubling, perhaps. I'm not sure we need it. I would tend to agree with Kent, but Jack, did you have any thoughts on this particular?
Yeah, it seems to me that in listening to this discussion that what we ought to do is we ought to take whatever's not already in the first list. I guess it's under number 1. That's in the second list under old number 3, current number 2. Add it to number 1, and then just have a explanation, and then have a recommendation. Number 2 be agencies should something like what was originally number 4 about plain language, putting all the guidelines, published regulations, and also the guidelines, and where they should be, something like that. I mean, it should publish guidelines reflecting something like agencies should publish guidelines in plain language reflecting the policies governing public access, the regulations governing public access to adjudicative proceedings. Because in number 1, we already say these regulations should cover all significant matters pertaining to public access to adjudicative proceedings, including the following. And I think that everything in old number 3, current number 2 is significant. So in a sense, it's like I think you could just put everything in there in one recommendation, and then have a separate recommendation saying you should publish guidelines in plain language and put them on your website in a prominent place for members of the public. Does that seem logical to others?
I think it does to me. Hi, did you have any thoughts?
Yeah, that was along the lines that I was proceeding on, thinking about. But maybe what you say is in conjunction with such regulations, agencies should develop, and I always think about it as guidance rather than guidelines, but regulations such as should develop guidelines that, and then I would just say that set forth in plain language, because we're not really explaining, that set forth in plain language. And then I think we should look at each of these and see if these make sense, right? Which ones are open and closed under the procedural regulations. So that'll get us the presumptively open and closed, et cetera, if you reference the regulations.
I think I heard Jack proposing that the list under 2 be moved up, and that new number 2 simply say that reflect these regulations.
Oh, I see. Okay, well then that goes to another point that I was going to say to someone who had actually said that, I think maybe even before Jeff, which is, I don't think some of this stuff should be in the regulation itself. So for example, who members of the public should contact if they have questions. This you want to have in just like, it's almost like FAQs, you know, on the website that you can easily change, you know, whether they need to register and where they register, the expectations for decorum, who they should contact. Those to me are all like FAQs on your website.
That makes sense. Bill, did you have something to add on this?
I was going to say, I don't think we should just move everything in 2 up to 1, because there are things that shouldn't be up there. And this is where you'd actually put the names and telephone numbers and addresses, because this is the stuff that you could change easily without going, you know, with the whole ball of wax of regulations. So I mean, if there's something in here that we really think ought to be in 1, then maybe we should put it in there. But I thought what was extra here didn't apply to 1. So I still like having it as these things here in 2, and just recognizing this is where you're going to get into the detail of things that you wouldn't want put in permanent regulation.
All great points, which I think takes me back to Ken's point, which is that I'm not sure A needs to be there. Russell.
Well, I would favor keeping 2 in this modified form. And item D is new, I think, about equipment, but I would rephrase that, expectations for decorum. You're really talking about requirements. You're not saying we hope you won't bring an electronic device in. We're saying specifications of I don't know quite how to phrase it, specifications of you know, behavior by observers.
It's
if
conduct.
You want to say
really.
You can't bring a recorder in, you know, that sort of thing ought to be made clear. That's a controversial point, but these are things that aren't covered above, for one thing, and I don't think the phrasing of them is quite accurate.
Yeah, I was questioning whether decorum was plain language, but that's again.
Well, expectations and decorum both. I mean, it's not just we hope you'll behave yourself, but these are the things you can and can't do without an exhaustive specification.
Hi.
Yeah, I just want to close the loop then in terms of language on what I said, and also Jeff. So in line 26, I'm sorry, in that section 2, I don't think we want A anymore, because that you have in the regulations, right? So in conjunction with such regulations, agencies should develop guidelines as set forth in plain language, and then the rest. And I think, again, I really do want us to go through and make sure we agree that each of these should be just in a sort of FAQ document and not in the regs itself, now that we're making that distinction. But some of it I think is fine. So for example, 1B is essentially duplicative of now what would be 2A. That's okay, because that's where you're actually giving the location, the thing that you might need to change. So I don't think it's horrible if it duplicates to some extent, but let's just run our eyes over this and make sure.
Russell, did you have something else on this or just your hand? Oh, okay.
No, I didn't.
Okay. Anything on A through G? Okay, then let's move to the last. Oh, Jeff, I see you waving.
Well, whether and how members of the public need to register.
Anything further?
This is just a short editing thing. I think how they need to register may not work. So whether members of the public need to register before attending open proceedings and information
About how?
on how to register.
It's better.
I just wondered, is there overlap between C and F in terms of the mention of audio visual equipment? Is C really trying to get at, just like we said, behavior and conduct if you're going to be present versus what the media may or may not do? I wondered if C really needs the EG, if it should just be requirements for conduct and not include that. I mean, that's a broader, to me, that's a pretty broad subject and what we expect when you show up.
Although what you can bring into the court, into the hearing room, it certainly is in the court's context. It's very touchy. Some of it depends on, not taking the picture of defendants, but which wouldn't apply here. But I think that's something that has to be, we have to recognize it's an issue.
So you would leave it in?
Some form of it, I would, but I mean, I defer to others who know more about agency proceedings than I do.
Hi.
Yeah, I actually think there's utility in leaving it in, at least as an EG, because we might want more. But I was also looking at that on F because it has both information about media inquiries and use of audiovisual. And I was like, what is instructions for reporting? So here's what I would think. Some of this might take a little time before, let's say, our next meeting, but I would look to see logically whether some of these should be moved up, like, where and how. A is fine, where and how, whether they need to register. And then I feel like the current D should be C, who members of the public should contact if they have questions. And then same thing, instructions for accessing it would then be D. And then you have what are sort of policies. So that's all like information, how to get stuff. Then you have, I would do what's currently you have a C, put that on after what is currently E, I think. Okay, so now we've got all the instructions about accessing. Now we're going to talk about requirements for conduct. Like, can they bring in the electronic devices? How can they use it?
Yeah, no, I see what you're saying. You're trying to group things by.
I'm trying to group things, and then you logically have these three things together, and then people can understand.
Right.
And we can ask ourselves, is there too much overlap? So there's the requirements for conduct by the observers. That's the first. That would go after whether you can observe the open proceedings. Let me let you just do that so then we can see.
So that one drops down.
That one drops down.
After D.
Yes, after D. So
No, well, maybe it's C.
it is. It's the new D. Right there, right after can observe open proceedings. Yeah, right there. Put in the expectation. Okay. So now we have requirements for conduct.
And then the reporters.
And then, so right, and are we talking about media reporting? Instructions for media reporting? Because that's also very much overlaps with policies for managing proceedings that attract high levels of public interest, which by the way is very broad, but I think it's fine to add. In other words, yeah, I think I'm just still not sure about reporting. Like, is that by both media and others? Because if it's others, I feel like you have that in this current new E, right? Public observers, although conduct, you may not realize that conduct also includes whether you can record and then display.
You almost want to say any requirements for conduct by media. You know, echo E, but, you know, public observers, I guess, could include media, right? But to the extent that there are special rules for media.
Right. Any special requirements?
Mark's shaking his head. No?
No. Okay.
You start talking about special rules for media, you get into broad.
Okay. All right. That's fair. The rules should be equal to all, no matter who's attending. Is that the idea? Okay.
Right.
Can we just say electronic devices and not say, I mean, I don't think we need to say and audiovisual equipment. And it's not just the use of the devices, as it's also the bringing in or the possession or some other word.
You can bring in a cell phone, but you can't bring in a big tape recorder. That's the point.
Right. But some, as you said, some courts don't even allow you to bring in the cell phone.
Right.
But an electronic device is an audiovisual piece of audiovisual equipment now.
Just give it. We can't make the policy here, but we can just indicate the range of things.
Yeah.
Roxanne? Oh, you're muted.
Sorry about that. I was wondering if it makes sense at the beginning of this list to add how to communicate the schedule of open proceedings to the public, because we talk about A is where they can observe it, where and how they can observe it, but just also where are you going to post the schedule of proceedings? That's another detail.
So you would put that as A?
I think I would. I think it starts with how do people even know you're holding these proceedings? And then, okay, well then how do they get in if they're interested? And you know,
where, maybe it's where, well, yeah, let's say
where or how.
Where and how agencies
will communicate the schedule of open proceedings to the public.
Because that's in number 11.
That's number 11?
Well, we talk about advance notice.
Okay.
11 and 12.
Hi, did you have your hand raised again, or it's from before?
Yeah, no, I did have it raised again on, and now on two matters. I do think in terms of the organization, it really did try to go from general to specific, which is why we're having some of these issues. I don't think it's bad to keep going on what we think needs to be here and then deal with it by cross references or ultimately tightening this. So I just want to acknowledge that, yes, this might be elsewhere, but that doesn't mean we should just keep a pin in it by putting that in. So that was my new comment on lines 30, 31, new A. My other piece was, though, I really do think that new G, lines 44, 45, we really need to understand this better in terms of what the authors were trying to get to. Because looking at it, I'm like, is instructions for whom? Is this instructions for the agency staff? Because that's certainly information about media inquiries is going to the agency staff. But use of audiovisual equipment seems like it's going to other people, and then it is duplicative of F. So let's just hear from, can we hear from Jeremy and Mark about what they were trying to get different between those two pieces?
Sure. In lay speak, we're talking about media. Mark, you may want to speak more about why that's problematic.
Sure. It's problematic because the general rule of the law doesn't recognize distinction, special legal rights for the media versus the general public. You're going to afford rights to some people, you afford them to the population at large. But yeah, as Jeremy said, in general, the idea behind this is reporting on agency proceedings, whether that's live reporting, for example, live tweeting a hearing, or something more.
Okay, so you did mean what is currently G to be specifically about media, and because there might be other considerations, First Amendment or others that might come into play?
That's true. And there's also even just practical differences, pooling, that kind of thing.
Exactly. Then I would just make that clear, G, instructions for media reporting on proceedings. I don't even think you need the EG there, because then what you're having is instructions for, and this is a nice in terms of going in categories, you are having instructions for media reporting on any proceedings, high level or not. And then second, if you scroll down, think ahead of time about what your policies are going to be for managing the proceedings that are actually going to attract high levels of public interest by media and otherwise. So that works better for me if other people agree.
One thing I would be cautious about is we're not talking about how the media can report on proceedings. It's practical aspects of access to proceedings or recording during proceedings, not what you can say after the fact about it.
Oh, that's true.
That's the reason I wonder if the word instruction is just gonna scare First Amendment people. Instructions, it's like you're telling the press what to do. I'd find another word for that.
So, procedures. Well, I don't know, maybe you have to think about it, but procedures is definitely better than instructions.
Protocols?
I like that. And again, I'll just raise again, we want to say open proceedings. We tend to go back and forth. B says open. D says proceedings without open. I'm just flagging that, Committee on Style. Jack?
Can we change the word reporting to coverage? Because so that it doesn't seem like it's instructing them on on how they report on it.
Much better.
I think you found your wordsmithing abilities. They're back.
I'm eating lunch now, so I'm getting a little recharge. That's why.
Excellent. Okay. Renee. Hi, Renee. Can you unmute? Unmute, please.
I turned my video on, but forgot the mute. So on that last one, are we talking about, providing information to people about how to report on the, people outside the agency on how to report on what happened at the proceedings? Or are we saying that the agency should have its own procedures for how it provides information about the proceedings to the public?
Jeremy or Mark, did you have any thoughts on this? I get the sensitivities here, but I mean, really what we're talking about is if you're going to be present in the courtroom and you're a member of the media.
Right. We're talking about how members of the media actually access and use the courtroom, essentially. Can I bring in bulky equipment? Can I move around during the thing? Can I take notes or record things? If there's too many of us, there's not room for all of us. How do we pool issues like that? It's not ever meant to be about what you're actually saying about the person.
Yeah.
Yeah.
Okay. Covering. Well, I don't know. I think maybe instructions maybe then is the wrong word. So maybe it's policies for why don't we say, media coverage or whatever on proceedings? I mean, I know we don't want to limit it to that, to quote unquote media, but.
That's facilitating media coverage.
Yeah.
Protocols.
Yeah, exactly. Or something. Because I think instructions seems very, raise the hackles on the back.
Jeff had proposed protocols. What do you think of that, Renee? Protocols for facilitating media coverage.
Yeah, that's fine. That's good.
I think the facilitating helps. I like that. Anybody? Yeah, Roxanne, did you have a thought on that?
I was just going to say, why even separate F and G? I mean, maybe we should just be saying any requirements for conduct by public observers or media at open proceedings, because we aren't trying to tell them what to write. We aren't trying to tell them that they can't write. There's certain things they might not be able to do, like they couldn't video record or something like that. And those same rules would apply to the other public observers,
including media.
So that's just a thought. Oops.
Some are not necessarily requirements for conduct. It's we'll put you in touch with our communications director who will help you gain access to the building. Those sorts of things, which are not so much requirements for conduct, but just how do we facilitate media access.
I liked Roxanne's instinct to kind of put them on equal footing there in that one, right? But I see what you're saying, that some of what G is accomplishing there is who do you talk to about, I want to show up and.
Right. I mean, you could throw media in D as well, who members of the media and members of the public and media should contact. Maybe there's a separate route for media inquiries, something like that.
Yeah, that's good.
That's good.
Yeah, that's good.
So do we want to keep media in F, and should that be or and? Hi.
Yeah, I thought we had said at some point that public observers would include people like the media, and I don't think we want to assume that it doesn't. And I think there really is a difference between requirements for conduct, right, possession and use of electronic devices, and the protocols for facilitating media. So I wouldn't put in on media there. And again, I'm thinking about, so how is this of utility to agencies? What we've done for them, down the line, if they implement, we've sort of thought ahead of time all the things they might want to think about. And this is their checklist. And they may not have been thinking about media and pools and stuff like that. So that's why I think, although there's some overlap between F and G, I think there's utility in separating those two and assuming media is already covered, public observers.
You would take or media out from F.
Yes, or not insert it.
What about keeping it in D?
Yeah, I mean, it's not really necessary. I don't think it's necessary. Let's just keep members of the public, which of course includes the media. And then we have G, which is something specific for them and protocols for facilitating their coverage, which I think was a very good addition.
Anything further on that? Okay. So let's move to anything on H. I think that's pretty much. And then 3, which is, of course, I always have my issue with publish and post. When I see publish, I think you mean Federal Register, but what you really mean is to post it on the website. So I will put in a plug for post there, but whatever ACUS protocol is, I'll use protocol like that. We want to post this all on the website, right?
I'm a big believer in post.
I don't know, I just, as an agency, I see publish and I think, oh God, they want me to put all this stuff in the Federal Register when that's not what we need.
Exactly.
You need to change the numbers, paragraph 1 and 2.
I would like to comment
Oh,
on
sure.
this section.
Yes, Bill.
I don't think we should tell them to publish the regulations on their website. That is, if agencies already have the policy of publishing regulations on their website, then they'll do that anyway. But if they don't, then I don't see why these regulations should be on the website, especially when we're going to have the guidelines on the website. So it's in terms of what we want to have. I mean, it just seems to me the regulations were available, and what the ordinary person needs to see probably is the guidelines, and that's what needs to be in the website. I just don't think, if agencies don't have a policy already of putting regulations on their website, I don't think why these regulations should be treated differently.
Just keep in mind here, maybe this is for our next meeting and interim drafting, is ACUS does have a recommendation on adjudication materials and how they should be addressed. And I think so. I think that insofar as possible, whatever is said here should comport with that recommendation. This issue will come up in another recommendation this fall, but maybe it's something we could look at for the next meeting.
We post, obviously, we post our rules of procedure, our regulations on our website. I don't think this would be difficult for an agency. I welcome anybody else to kind of chime in on that. You know, maybe if you had the guidelines, you could have a link that would take you to the regulations.
I mean, just so you, Nadine, I think the prior recommendation does refer to posting regulations. So I think we ought to just be a little bit careful here so we don't work at cross purposes with other recommendations.
I see Mark shaking his head, so I assume he's checked. Okay.
Yeah, I think it's 2018-5, which is public availability of adjudication rules, I believe. So, but we
I don't
make
have
sure
any of those numbers in my head. Thank God you do. Okay, so
yeah,
we'll just leave it. We don't want to be at cross purposes. Okay. So let's move to the next section. This is now number 4, obviously. Oh, okay. It's just, it looks like it's struck through because of the, never mind. Anything on 4. So here's where we get to some of the details about closing. And this is consistent with our prior recommendation, the number I don't know, where we've said there's a presumption that they're open. And so here's what you need to think about in terms of closing. And these are derived largely from statutory limitations.
mirror 2016 for and then virtual hearings. The only addition is E.
Okay. Bill, did you have something further on this?
Yeah, I have a question, simply a question.
Yeah.
Is the participant's privacy, would that be what would include it for Social Security disability?
I would say so.
What about any type of disciplinary action against an employee?
Probably D, but if not, I think it would fall under E in
E.
many cases.
Well, they're interesting. Well, I guess then I'd ask what law would protect it, but okay. Just as long as you think that these sort of personal.
I'd have to check, but I think FOIA and Privacy Act, at least one of them, at least, if not both, refer to personnel matters.
Okay. All right. Thank you.
So we do have an edit suggested there from the judge. I'm not quite sure how he's envisioning it added. Including minors or e.g. minors? I'm not quite.
Privacy for participants, including minors and juveniles.
Ooh,
Or privacy of participants, I don't know.
that's better.
I thought he wanted it as a separate item.
Oh,
Either as a new D or a new E. Protection of the interests of minors and juveniles or something like that.
but that's redundant of the
Or
opening.
juvenile. It's redundant of what?
So it says only to the extent necessary to protect one or more of the following interests. So to repeat, protection of the interests.
Oh, the interests of, well. So I guess you could just say minors or juveniles.
Yeah, I think that's, if he wants it as a standalone, that's what it would be, I think. Any thoughts on that? I see Russell.
Just a question, is whether or not, I mean, this purports to list every possible exception. And I wonder if some agencies might have very specific categories that wouldn't apply generally, but that we need to recognize here. And I can't think of any. I apologize for that. But there must be, you know, the Bureau of Minor Ship Repairs must have some special category that wouldn't be covered here, but I would think, I guess I'm just appealing to people who know more about it than I do, whether or not we need some sort of a escape or recognition that there may be specific items that particular agencies want protected but aren't covered here.
Doesn't F do that? Doesn't F do that?
No, it says protected by law.
It says other interests.
Categories of information.
Four categories of information. It's a little ambiguous.
By law, but could there be some in which there's not a legal requirement, but that for one reason or other you might want to keep out, or is only items covered by statutory law are covered here? If that's the case, then I withdraw my comment.
By statute or agency rule?
Yeah.
It at least requires it to be in a regulation as opposed to an ad
Let's
hoc.
try that. Let's try that. Statute or agency rule. Is that what? Yeah. Hi.
Well, I was going to speak against sort of letting it be up to the agency. Not sure if I think we get it by agency rule, because to me, the utility of putting something like this out is saying to the agency, if you can't meet one of these things, okay, then we're saying to you, you should adopt the presumption of it being open. Now, they can decide to go with this or not, right? It's not like we're writing a piece of legislation that will absolutely bind them, in which case I think we do have to, you know, be more concerned. We're saying we think there should be a presumption because, again, when you think if we want this to make an impact out there in the world, we need to potentially interrupt longstanding practice. You know, longstanding practice, I didn't even realize in the EEOC rule that it says for our administrative judges that you can't have people in those oral, you know, in those hearings that can't demonstrate some interest. You know, I mean, that even might be in a rule. It's certainly not by any law. So I take the point about it doesn't take into account everything an agency might use. And I actually think that's a good thing. I guess that's my point, which is why I don't think I'd be really in favor of adding or agency rule.
Well, I can appreciate that. You create an open door for everybody to run through.
Yeah.
Bill, did you have another point?
Well, yeah, yes, and a question responsive to this. I mean, as I understood Chai's comment, which is she approves of keeping agency rule.
No.
No, you want to get it out. And I was going to speak in favor of, because I understand your concern about the agency just saying, oh, we just don't think it ought to be open, period. All right. But if they have to adopt a rule to identify that interest, all right, I think that's enough of a burden on them that they'll only do it if it's really important. And it will be done through a public process in which, or at least a process in which somebody can object and say that's not a good idea. So I was originally just going to say information protected by the agency, period. But I think putting agency rule is really a lot more protective of the openness by assuring that the agency would actually have to go through some affirmative process in order to say that this was an interest that deems to be closed. That's my comment. I had a question, however, originally, which is when we talk about closed meetings, if a Social Security disability applicant wants to have their spouse with them, all right, is that okay in a closed meeting, or is that mean that the spouse can't be there? And if the spouse can be there, does that mean any member of the public can be there? The question is, can something be closed to the general public but open to the people invited by the parties to the proceeding? Is the sort of question I have here.
Jeremy?
Yeah, and we get at that in line 65. That's at least, that was the idea behind that. In some schemes, yes, proceedings that are presumptively closed can be opened to individuals with the consent of the parties. I don't want to speak to Social Security specifically, but there are some schemes where that is present.
Any further discussion on F? Hi, were you persuaded by Bill?
No, I wasn't, which is why I just raised my hand again. I mean, I think this is, sometimes there are some things that really, I think, do end up making a real difference, which is why I think it is worth sitting with this a bit. I'm not so sure that an agency would think by a rule that it's even necessarily a regulation. And I am curious about, like I said, I didn't know that existed in our federal sector hearings. And I'm curious whether, I'm not expecting you to remember right now, but whether that is in our 1614 regulations that say that, which means we would want to actually have to revise those regulations, or is it some, manual, etc. So I would still speak against having or agency rule. I like the idea of saying other interests or categories of information protected by law, because obviously they have to do that, and we look silly if we don't, include that. But I don't think we want to give them the loophole in our recommendation. Again, they can do whatever they want to do, but I don't think we want to say that we're okay with that. Even if they put in a reg, like maybe it's in that 1614 reg for the EEOC hearings. So that's where I'm at on that.
Jeff, did you have a comment on this?
I prefer law, because that would include statutes and legislative rules or regulations. And so,
okay, that's fair. Okay. Bill, did you have something further, or we're good?
Yeah, I'm still, I mean, if if Jeff wants to include agency regulations, all right, by using the word law, then I think we ought to say statute or regulation, agency regulation. If Ty is worried about rule being something less than a regulation, fine, I'm happy to substitute the word regulation. But I think if we want to recognize that, as Jeff seemed willing to be able to just change, say it's a regulation is law, therefore the agency adopted that law. I mean, it comes back to what Russell said, which is, I don't feel confident that we've identified every possible interest that would justify closing a proceeding in this list here. And if I felt confident about it, if I knew others, that I'd put them in, but I just don't feel confident enough to say, boy, oh boy, agencies, you're bad guys if you don't open up in these except in these circumstances. I don't think we're really that familiar with all the different agency proceedings to have that confidence.
Any other comments on this? Awfully quiet.
I mean, I do prefer regulation to rule. So
I do
that's,
too.
I mean, I don't know if that's enough of a middle ground for Kai, but it's at least it's better than some manual.
Yeah, so it'd be by statute or regulation. You know, I think for the moment, you know, I'm fine to put that, to leave it, but I would want to put a pin on this in terms of, as a committee, before we end up voting on it, that this is a really important issue, and I might want to actually go into the report a bit more and see what's there in terms of in regulation, so that things that have been done in the past don't just continue because of that. But I think for purposes of, but I also totally take Bill's point of, you know, we also don't want to look silly by not acknowledging there might be something real in an agency regulation about some interest or category of information. So I'm fine with keeping it statute of regulation now, but if we could just put a pin on it, it's something I'd want to come back and discuss before final vote.
I mean, it might be under-inclusive. I mean, there might be privileges, executive privilege or something, some common law privilege that isn't encompassed by statute or regulation, but it is encompassed by law.
You know, you could just say something like, this is another idea, on line 52, I don't even think I'd like it, so don't put it down. I just want to say it. Only to the extent necessary to protect a substantial interest, such as, see what I mean? And that goes to your point.
It's more open-ended.
If it's more open-ended, but we still requiring them to go through that process, and we at least have said the standard is it's a substantive interest. Like, what exactly is the substantive interest that you're furthering by saying it at EOC federal sector hearing that only people who have demonstrated interest can come? So that could be, I mean, maybe you can put it in.
Mark, did you have a comment?
I'd have no problem.
I did have a.
Go ahead, Mark.
I had a question for Bill, which is, and it goes to what Kai just mentioned. If in what's now line 59 sub F, if we put other similarly compelling interests, comma, or categories of information protected by law, would that be the catch-all language that you seem to be suggesting?
I certainly don't have any problem with putting in other substantial or significant interests in F or in the introductory language. I like keeping statute or regulation rather than law, because a lot of people read law to mean just statutes. And so I'd like statute or regulation preferable to law, but I have certainly no problem with substantial interests.
But I'd like, and this would, I'd like other similar
Similarly compelling, I think.
Similarly
Mark said.
compelling interests or categories of information. And then once we put that limitation, I'm actually fine, Bill, with statute or regulation. I no
Thank you,
longer
Mark.
need the general
Thank
law.
you, Mark. All right. Anything on the next line? I think that's all one line, I believe it is. About this kind of hybrid look that Jeremy explained a minute ago. Okay.
Where's,
So we'll move. Sorry.
where's Jack when we need it? This is a pretty long sentence.
Yeah. Well, we'll move
I'm
to
here.
5.
I'm here. What can I do? I'm sorry. Was eating my lunch.
Line 61, the sentence is too long.
You can put it in the active voice and shorten it a little bit. That presumption that agencies will close hearings and proceedings while retaining the authority. I think the active voice is better there anyway, because you're asking who's doing it.
Yeah, where would you put that, Russell? Can you flesh that out?
Replace, it may be appropriate. Let me just read from my text here. Presumption that agencies will close hearings and proceedings while retaining. I don't know if that shortens it at all.
That's one, I'm pretty sure I missed a word from you.
Yeah, I think there's something missing.
Interest in open proceedings.
Maybe it's the first part that needs to be.
Yeah, I thought you were going to say for programs, agencies may presume, so take out a may be appropriate to, which is the, agencies may presume that evidentiary hearings and appellates.
Yeah, while retaining.
Right, will be closed to public observation while retaining the ability to open the proceedings in whole or in part.
Just in that last thing. There may be other ways. We could have the committee on style work on shortening it.
I mean, it's active voice whenever you can do it.
Yeah. Okay, let's move to 5. Anything on 5?
Well, I see the sidebar note that Jeremy put in, but I'm thinking of what Matt said earlier, whether you can't presume to rely on the preamble and whether you need to give an example here. He said pre-hearing conferences, which is what the report refers to. Just ask the question for ACA style whether you need to have a for example. Even though, as he says, it'll be mentioned in the preamble.
I'm fine with it either way. I mean, I don't think ECAS necessarily has a protocol in this space. I mean, obviously it makes it longer, but if it's clear to you all and readers, I think it's fine.
You'd add the EG after proceedings?
Pre-hearing conferences, settlement conferences.
I think EG, all I have to say is 1.
Just 1, there you go.
I think so.
Right after proceedings there, the appellate proceedings. Is that where it would go?
Yeah, appellate proceedings, evidentiary hearings, appellate proceedings, and appellate proceedings.
Oh, okay. e.g.
Like of adjudicative proceedings other than evidentiary hearings and appellate proceedings, e.g. pretrial hearings. And then with the preamble, you know, it concludes in a more extensive discussion, all the better, but at least you don't leave the reader sort of wondering what it's all about.
Okay. Anything further on this one?
Well, B has the same problem as we just went over at the end, protected by law.
Yep. Or
So,
other similarly compelling, yeah. Mhm. Anything?
and the next one's C. I didn't really get or a broader adjudication process. That's will raise the question mark. What does that mean?
Yeah, I wasn't sure. Can you explain that one, Jeremy?
Yeah, the idea was that individual proceedings take place as part of a broader process for adjudicating cases. So obviously you have a variety of proceedings, pre-hearing conference, evidentiary hearing, appellate review, which could all be part of a single adjudication process. So if parts of it are public, it's worth considering whether other parts should be public.
I had a comment generally on this whole section, which is that at least as to some of the kinds of some of the proceedings that are identified in the report as yes would be included within this section paragraph, I would say the recommendation ought to be that they shouldn't be public or open to the public. I mean, I didn't see the case in the report for why these should be open. Now, I understand that in languages agency should consider, all right, which certainly leaves it open, but that would be like saying agency should consider whether, you know, anything. I think that the value of the administrative conference is to identify what we think is a good idea, and here, there may be some of these proceedings that we might think in some cases might do well to have public access to them, but some of the things that are identified in the report is that I think would be included within the definition, what we covered, I would think would be quite odd to have them open to the public, and they certainly aren't in the judicial context in any case, I don't think. So I was very skeptical about whether we should have this at all. That's my
Jeremy or Mark, did you have any comments on this in terms of how the report kind of touches on this?
Yeah, there are certainly agencies that have made like pre-hearing conferences open to the public. Some of the financial agencies have done that. It might depend on what's going on in those. If you're actually having some sort of dispositive motions practice, maybe that's more important than just scheduling or deciding on discovery schedules. There have been some First Amendment cases brought involving public access to what you might call a fact-finding hearing or investigative hearing, the kind of thing that like the Mine Safety and Health Administration does before issuing a complaint. So there is sometimes public interest in attending these proceedings. I would say the judicial context, there was I forget the case, out of the Third Circuit years ago about public access to an arbitration proceeding. So there is sometimes public interest in attending these proceedings. I think I agree with you that in most cases, they would be presumptively closed, but I think it's important to encourage agencies to think through whether in their specific programs it's worth opening them.
Mm-hmm.
What exactly are we talking about here? I've heard pre-hearing conferences, oral argument. These are some different concepts going on here that you wouldn't necessarily want to treat alike.
Right. The proceeding recommendation paragraph 4 deals with evidentiary hearings and appellate proceedings, oral arguments, using the same phrase that was used in the agency appellate systems. This deals with everything else. I think evidentiary hearings and oral arguments are the clearest case where if anything is going to be open, these should be open. As for other things, the presumption is not necessarily as strong, but it may be worth agencies considering whether some of them should be open.
This includes settlement conferences?
Yeah.
Yep. I mean, the way we structured is the factors below might counsel in favor of closing.
Right, right.
I think B is whether it would impede important policy objectives such as encouraging candor and achieving consensus, which is squarely ADR.
You can certainly apply the framework
right
to settlement conference, but I think the answer will be fairly clear.
Right.
Maybe we need the reverse presumption for these.
That they would be presumptively closed unless the agency determines.
Or just say that they are often or usually closed, but in some cases. That's what I read Bill is saying.
Well, would it be that are presumptively closed should be open? I mean, or are you saying we should? Yeah, maybe that's what I was thinking. I don't know. Jeff, does that kind of align? Do you see the language with what you were saying?
No, I think this doesn't really meet Matt's question because there's so many subparts here that I mean, I don't think settlement conferences should be open in very many situations.
Agreed.
Matt, did you have something more on this?
Not on this. I have a more general comment, but I think it probably should wait till you guys wrap this up.
Okay. Any other thoughts on this language that's there now that would completely change the meaning of this recommendation?
Is our schedule to be over at noon or 12:30?
Oh, we are going till 4. Is anyone, we can take a break if people are interested in a break. We have another hour.
Okay.
We might get a little more focused attention after a 5-minute break. Would be my sense, especially for something that's going to, as you said, sort of change.
Yeah, completely flips it, right? Well, maybe not completely because it was either or. It picks a side. We can take a break, absolutely.
Okay, good.
Minutes.
5 minutes. I think that's my cue. Okay. Seeing people pop back. Yes. All right. So hopefully we're all refreshed and ready to tackle this particular recommendation that we've now changed. I think this works, but if on further reflection, someone has a comment here.
You're talking about line 67 to 69?
Correct.
I went back and read the report. It's on page 20 of the report. It said a few agencies, a few agencies like the Consumer Financial Protection Bureau, Product Safety Commission, Federal Trade Commission have adopted policies that presumptively open pre-hearing and scheduling conferences to public observation. You know, I think that's good enough to leave this in.
So you would leave it unchanged, or you would leave it the way it is now?
I leave it the way it
was
been amended.
Okay, great.
It doesn't quite work now. The while retaining part doesn't fit anymore.
Mm-hmm.
Line 70.
Should it just end at public observation period?
And maybe we could say often closed rather than presumptively closed.
I think that we had something like that before, but typically, often.
Or usually, or typically, yeah.
I think that works. Any other concerns, objections? Okay, so these are the considerations, right, that we want agencies to think about, and now we have to think about it from the opposite perspective, right? Or no?
No, I don't think from the opposite perspective.
Good.
Yeah, no, I don't think so. And I think
Okay.
it worked above.
Okay. So A through F, do we have anything on A through F? Thank
I'm
you
still
for
not
catching-
satisfied with C.
Yeah.
I understand what Jeremy's explanation. I understood his explanation, but it needs to be a little bit more spelled out. I think whether proceedings of that type or the broader adjudication process that it is a part of, or something like that. I mean, it's not just any broader adjudication process, or the related, or the no, I don't have very good idea here, but of which it is a part.
I would take out related.
Okay, I understand it now.
That seems, yeah. Okay. Anything else on this list? Oh, hi.
Yeah. Sorry, but better to catch this now. Just looking again at what we did on lines 81, 82. We can't really do similarly compelling interest if we're going to say protected by statute, because even if it's an absurd interest, if it's protected by statute, the agency can't do anything. So, and it's, I think, a little too clunky to say, so I think we should take out similarly compelling in front of interest. And then it's a little too clunky to say, and similarly compelling by regulation. So I think for the moment, I would take out similarly compelling here as well as above. We may want to go back to putting that similarly compelling idea somewhere else, but so I think we just need to think on this more, and I will, but that legally we just can't put in similarly compelling, that qualifier. Right, I'm assuming other people will agree with that. I mean,
so it depends how you read this. Other similarly compelling interests, or categories of information protected by statute or regulation.
Is it modifying only interests, or is
that could work?
I don't know. Maybe you need a comma.
Yeah, you can put a comma, but then it's almost like those are two separate things, and then you've got similar compelling interest. I just think this is both really important and really tough. So, so maybe the way to hold it for the moment is with the comma, but just know that we have to come back to this.
So we would add the comma after interest.
Yes. Let's do that for the moment.
Okay.
At least,
Oh,
yeah.
there had been the recommendation to put the similarly compelling or compelling, substantial, or significant up in the introductory language,
Yeah.
and then such, and then saying such as, and then including the full list of A through F.
That had been my original idea, and which is I just referenced, and then someone suggested putting it down below.
Yeah, I think that works to put it up there.
Put it up there. So, okay, where is this? Can't read anything. Should adopt the presumption. Open.
Line 52 to 53.
Yes, thank you for blowing that up a little. Only to the extent necessary to protect a compelling interest, such as, and then it's such as national security, law enforcement, confidential business, petitions, minors or juveniles, and then categories of information. Oh, then you don't actually need to do it because it's such as, but, or you could say, you don't have to do interest, categories of information protected by statute or regulation. You know, I'd like that, by the fact that it's categories of information, that could help. Other categories of information. Because then it's an actual category as opposed to, oh, we just don't want people here. It's still not perfect, but it's better. And I will take it on to keep thinking on it.
So on that line, 80 to 81, we would take out similarly compelling, or we would leave that.
No, you know what you would do? No, you would do the same comma, other similarly compelling interest,
Yep.
or categories of information. And then you take out the or before similarly compelling interest. Yeah. Yeah, there.
Mm-hmm. Okay.
Okay.
Anything else on this list before we move to 6? Okay.
Nadine, can I offer my sort of general comment now?
Yes,
it might be the
absolutely.
right place.
Sure.
I think I'm probably going to make Mark sore, but I'm going to say it anyway. So the comment is this. So we've got ACUS in this recommendation pronouncing on when basically agencies should open proceedings, when they should be presumptively open, we're listing factors and so forth. What exactly are we doing? And let me be more specific. What about the First Amendment? Are we operating in an area in which the First Amendment is silent, or in an area that carves out discretionary space for agencies? Are we interpreting the First Amendment? I understand that. I understand this is a tricky question, but it seems to me that at very least somewhere in this recommendation, agencies kind of, you know, we need to recognize that the First Amendment is going to have a claim, a priority claim on whatever the agencies do. And is it worth, should the recommendations say somewhere, and not just in the preamble, that, you know, when issues come up, agencies need to consult with legal counsel to see if the First Amendment has a claim on their activities before they start weighing factors and so forth. I don't know how to deal with that, and I don't know exactly how to deal with that, but it is, I think, maybe an important consideration, and I suspect it's going to be one that we may hear sort of down the road from some of our members. I don't know what to do with. I don't know what to do about it, but I think we should sort of be clear what we're doing when we're listing factors. Are we saying, well, this is how the First Amendment interest should be balanced? Are we saying this is a space that the First Amendment allows agencies to operate in as a public policy matter? I hope you get the drift there.
Mark, did you want to?
I would suggest, yeah, and there's a lot to unpack there. As Matt said, it's a thorny and kind of a nuanced area of the law, obviously. One way to do it would be an opening paragraph acknowledging that these recommendations take place against a backdrop constitutional law in particular that is complex and evolving in some respects, and you can find that in the report. And as Matt suggested, refer readers to agency members to their counsel to address the issue further. But I think that might be a worthwhile starting paragraph would be my initial inclination, because I agree with Matt.
Are you thinking preamble or or recommendation, since it needs to stand?
I think you certainly the preamble, but I think you could do both. I think you could do paragraph 1, acknowledging the constitutional framework against which these recommendations have to be read.
Okay.
So I have a question, Mark. As I remember, there were these 2 immigration cases involving, the press wanted to cover them, and Department of Justice wanted to close them, and the government won one case and lost the other case in the circuit courts, but they didn't seek cert in the Supreme Court on the case they lost. So there was no Supreme Court decision on the matter?
Correct. The Supreme Court has never weighed in on whether the report refers to as the press enterprise framework applies to agency proceedings, especially agency proceedings.
So consulting with a First Amendment lawyer, what would the First Amendment lawyer tell them?
So the bulk of the decisions out there right now talk about all 3 of the federal appellate courts who have addressed this question head on in recent years have concluded that the press enterprise framework does apply. First Amendment test the court set out in a series of cases the Supreme Court set out in the 1980s applies to agency proceedings. And the difference that you identified, the report identifies between the 3rd and 6th Circuit decision is just a matter of how the courts in those cases weighed there was no dispute that the First Amendment press enterprise framework applied. The question was, okay, applying this framework, what results on the facts of this case? And they disagreed about how background facts in that case dictated the outcome. But I think a First Amendment lawyer would tell you that I hesitate to give advice to the First Amendment lawyer here, but my suspicion is that a First Amendment lawyer would tell you that there is a strong likelihood that the press enterprise framework does apply in most of the circumstances addressed by this recommendation, this project.
But in those 2 immigration or those deportation cases involving suspected terrorists, I would think, you had the national security concern on the other side, but there was also a pretty great public interest in such a proceeding compared to a garden variety Social Security proceeding.
Right. And what ultimately made the difference between the 6th and the 3rd Circuit decisions were their evaluations, particularly of the history of openness of those proceedings. The 6th Circuit was willing to conclude that removal proceedings had historically been sufficiently open, that the first prong of that experience and logic test was satisfied. The 3rd Circuit was not as generous in reading the history. And then that analysis trickled down into the second aspect of the history and logic analysis of the 3rd Circuit. That's really, that's the source of the difference between the courts. The court, there is no difference in those decisions as to whether you apply this particular analytical framework.
Jack, did you have a comment on this?
Yeah, I think that Matt is spot on that we need to flag this more than it's already. I mean, in the originally in number 1, we did mention the Constitution, I believe. So I had 2 suggested places to mention this, and I apologize because I can't scroll obviously through the document that's up on the thing, and I can't really see it. The writing is a little too small for me on my monitor, but if you go back to old number 5, which I guess is number 4 now, can we go to that? Let me see. Agencies should adopt the presumption that every engineer hearings may be closed in another part. Okay, so I have a suggested addition after the in whole or in part, comma, I would add the words only in part, only to the extent consistent with the First Amendment and other potential constitutional bases for requiring open proceedings, comma, and only to the extent, and then go on with what we have. Is that, did you get that?
Jack, can you repeat what you said after the word bases?
Bases for requiring open proceedings, comma, and.
To the extent. Yep.
Okay, and then at the next, I guess it's now number 5, I would add the same language while retaining the ability to part from agency should consider. I would add the language, it's very similar language. I would add the language First Amendment and other potential constitutional bases for requiring open or closed proceedings. Because you could have like a due process problem, for example, or a constitutional basis for requiring a closed proceeding. First Amendment and other potential constitutional bases for requiring open or closed proceedings.
Jack, do you have a line in particular?
I'm sorry. Well, I can't see. Let me look at the Zoom again. This is the problem. Is I got to see what line we're on now. I'm in the one that says hopefully enveloping policies regarding public access proceedings other than evidentiary hearings and public proceedings. Each consider at a minimum maybe we just should add a new A. Whether the First Amendment or other potential constitutional or other constitutional provisions require open or closed proceedings. And then semicolon.
Why don't you say due process, First Amendment, the due process clause, or?
Well, it could be, I don't know. There could be other reasons for requiring, there could be an equal protection issue. I don't know. I just don't want to, I want to flag the First Amendment and then leave the other part open. I think that's better because we don't want to limit it.
You don't want to flag due process concerns?
No, because no, I think First Amendment is the predominant concern. I mean, it's up to the, I don't care.
Okay.
If the group would rather see First Amendment due process and other potential, that's fine with me, either way. The longer the list, the more exclusive it starts seeming. That's the reason I was trying to keep it short. But I don't really, I don't think it would be bad to add due process also.
I mean, the First Amendment would never require closed proceedings, I don't think, but the due process clause.
Due process, equal protection, I don't know. The Bill of Attainder clause.
All I'm saying now is that
why not just say constitutional? Just
well, I think it's important to flag. I think it's important to flag the First Amendment. I think
why?
For the reasons Matt gave.
Well,
that I think there's likely to be people who are going to be thinking in First Amendment terms about a lot of this, and the First Amendment is the predominant basis for requiring open proceedings in these kinds of situations. So Matt, maybe I'm misreading you, but I thought you were most worried about people thinking about the First Amendment.
Yeah, I wasn't even thinking about mentioning the First Amendment in these specific recommendations. I'm neutral on that. I'm just more concerned about someone saying, well, what's the source of ACUS's recommendation? Are they policy considerations? Are they First Amendment imperatives? Are they policy are they policy recommendations that are derived in some manner from maybe under-enforced norms under the First Amendment? Like, what exactly are they, and could and should? And then the second question would be, should there be a recommendation that specifically says, look, you may get a legal challenge to closing a proceeding or a regulation or whatever it is, and you should ensure that whatever you're doing comports with First Amendment requirements to the best that, apropos of Jeff's comment, to the best that your lawyers can do. But you don't want to leave the impression that somehow, as long as you follow ACUS's recommendation, you're in the clear. That would be sort of the second point.
Okay, so I understand that, and I think, I mean, it's hard to. We've talked about this before in terms of we don't like to put in a recommendation telling people they should follow the law. And I'm not sure we want to put in a recommendation that when a legal issue comes up, they should ask for legal advice. But you know more about that, how that would come across than I would.
You may be right, in which case then maybe the preamble needs to make clear that ACUS is not pronouncing on First Amendment doctrine and how it applies in particular context, that maybe you say the recommendations are informed by First Amendment doctrine, broader consideration.
You just
Matt, you got muted.
I have a recommendation for dealing with this, which is a little different than Jack's. I would put it up front and put it really in the very beginning to sort of address Matt's point of saying, why are we making this recommendation and on what basis? And to say, and this is not the language I'd use, but the idea is that where the Constitution, the First Amendment or due process requires public access to an adjudicatory proceeding, and where agencies are not required to do so, but believe it would be or in other circumstances were not required, it may be advisable to have public access to meetings. Here are the recommendations as to what you should do, because that's what we're talking about, is what should you do with respect to public access. A lot of this is when there's public access and when you can close it, but the idea is that you'd start off by saying, where required, it may be required in some places, and on other places, it's a matter of policy that we think it's a good idea, or agencies should think it's a good idea. And I think that should be the beginning as giving the sort of rationale for the whole recommendation.
Judge McCarthy, before, I think you have to.
Yeah, I have to leave. I just wanted to follow up on Matt's and Bill's points. I'm looking at the project description on the ACUS website, and it says that the project examines factors including constitutional and statutory requirements that agencies should consider when determining whether to open or close particular proceedings. So I agree with Bill. I think that should come up front. It should be constitutional requirements, statutory requirements, which I think are listed in 5, or national security, law enforcement interest, confidential business information. And then it appears to me that what's left is kind of agency discretion to kind of balance public knowledge and transparency, which gets the presumption, versus all other considerations or standards. So I would kind of put that framework kind of up front. And with that, I have to go, but if there's any follow-up comments to that, I'll stick around for a minute.
Jack, did you have a response?
Yeah, I'm in agreement, and I think that the preamble would be a perfect place to say something along the lines of what Tom just said, and mentioning the First Amendment, other constitutional considerations, statutory requirements, and also the basic ACUS position about openness and good government, and how good government and accountability are all advanced by open proceedings whenever possible, but that there may be countervailing interests that are recognized in the constitutional and statutory sources, and also in policy that would lead to proceedings, certain proceedings not being open. I think that would be a perfect preamble for this, and it basically echoes the project description. So I would urge very strongly that this material, the constitutional issues and the statutory issues, be mentioned in the preamble.
Also mentioned that's the Office of Legal Counsel that provides constitutional advice. to the agencies, not ACUS.
So in the preamble, is there still thinking that we would include the language that Jack's proposed for the recommendations as well? Or do we want to hold that and see how it writes in the preamble before we decide whether to echo it in the recommendations?
I just want to say that I still think that, I mean, if people disagree with me, that's fine, but I still think it would be good to add this in those particular places in the recommendation. But if other people disagree, that's fine with me. I don't feel really strongly about it.
We can always revisit in light of what the preamble says. So why don't we do that? Thank you, Matt. Okay, where were we? We were back on our list, or we had moved past? We were on our list. Are we done with our list? I think we're done with our list.
Yeah.
Let's move to 6. Another list. Anything here?
Since you are able to blow it up just a little bit more, if you can. Okay.
I have a comment about C.
Okay. So there.
I think C mixes two different things. One is responding and the other is requesting. And query whether that should be two separate questions. How to request closing or opening, and then who responds. And does respond mean answer, or does it mean decide? Who can respond to it? Well, anybody can. I can respond to it if I hear about it, but I can't decide it. So I would consider anyway C and then the new D. Who can request or object to requests regarding public access, and who decide, or maybe make it just one C, but and who decides? Specify those things.
I think requests in 102 might be a typo. I think it should be responses or objections.
Oh, that oh, and how such
Because I think, well.
Oh, I see.
Mm-hmm.
Who can respond? Well, still though, who can respond? Anyone can respond. What agency official? Is that what you mean to say? What agency official?
The issue that comes up is whether this is restricted to, it's the role of non-parties in making these sorts of requests. The extent to which members of the public who are not parties or participants in a proceeding can request that a proceeding be opened.
Well, shouldn't that, well, maybe everybody's smarter than I am, but I got hung up on it. Query whether to make it clear that's what we're talking about. And I can't think of the language right now, but.
Hi.
What if you just said, following mirroring B, how individuals who are not parties to a case can respond to, or you can do how individuals, because some of them will be parties, right? How individuals can respond or object to requests regarding public access. How individuals can respond. You have that already. So just take out everything so you can see all we're adding is how individuals. Take out can respond and take out who. Exactly. How individuals can respond or object to requests regarding public and how such responses or objections should be made. So someone.
Is that redundant now?
What does that mean then? That some third party can respond to a request regarding public access? Or, I mean, I don't.
Yeah.
Yes. A party says, I'd like this proceeding to be closed, and a reporter says, no, judge, this should be open. That's exactly the scenario.
Or someone asked for something that was presumptively to Am I not, something that is presumptively to be closed should now be opened. Someone else should be able to say, no, I think it should stay closed.
Right.
Yeah, and the language that Mark has highlighted, do we need that any longer?
Mhm.
Isn't
Probably
it
not.
saying the same thing?
Mhm.
Mark, is that why you highlighted it? Thank you.
I want to say how such individuals, that picked right up from D, from B.
No, but it's different individuals. Different
Well, do
individuals.
we need to say both? So if you scroll up to A, can't see A anymore. So how parties can request, how individuals who are not parties.
That's what B says.
Right, but A
I
says
think so.
parties, B says individuals who are not parties. Do we need to use the same? How parties or individual, do we?
Can we refer to A and B? Would that make it more clear in terms of what we're trying to say? It's how individuals can respond or object to the requests made in A or B?
Well, that's clear.
This might have just answered it.
Okay.
Yeah, never mind. But is it clear? No, this was the thing about A, how parties to a case can request that it be closed or again opened. In many cases, you'll have one party, let's say, will request that it now be either opened or closed. The other party wants to object. And so if we say, I wonder if we just made individuals can respond or object. Yeah, I think that then works because we have individuals in C will be both another party or someone who's not a party. Okay, we're good.
Anything further on the list? Okay. What are we doing on time?
Nadine?
Yeah.
Just one quick thing. I was wondering, after parties right where we were with how individuals, should we say how non-parties can request access? Because I was thinking of the example earlier of a reporter who may ask for something, but could also be a news organization that's asking for something. So we could have something of a corporate type entity that's seeking access.
I think that's good. Anything further? Okay, let's move to the next one. We have 15 minutes, so let's see what we can do to chip away at this section. Anything on 7?
I'm sorry to go back, but
No, that's fine. I actually saw something I had too. Go ahead.
Whether adjudicators or other officials can on their own motion close proceedings. Don't we also want to say whether under what circumstances? Not just whether they can do it, but under what circumstances?
I was going to suggest when. I'm trying to think about.
I'm happy with when. I'm happy with when.
Mm-hmm. Mm-hmm. Jack?
Yeah, I wouldn't that just be redundant of all the things that are already in there about when you can have open and when you can have closed? I mean, it just seems like it's a whether question, not a when, to me.
Well, this is where nobody's asked for it. This is own motion, all right? So nobody's asked for it. We haven't addressed that yet. A and B are about when somebody asks for it. Here it's on motion.
I don't think it's a question of whether they can. It's just under what circumstances would they do it? Don't they have the authority to do that on their own motion?
Well,
No?
that's what this regulation could say. It could say you do have the authority, or it could say you don't have the authority, or it could say you have the authority. And if it says you have the authority, it ought to say what the circumstances are.
Jeremy, did you have a comment? No? Okay. Where's my judges to say we always have the authority to do whatever we want? Okay.
Can I just add to this? I think the very fact that it's presumptively open is the one that assumes that it might therefore be closed, even on someone's own motion. So what's wrong with going back to Nadine's, your first point? I thought you were just adding under what circumstances. Okay, I'm sorry, I withdraw. That's fine. When they can. But no, the thing is they can, because if they're presumptively open, that means sometimes they will be closed. And I mean, don't you think it's even better than under what circumstances adjudicators or other agency officials can on their own motion? Because that, when the answer is always, because it's just a presumption. I think this is better.
I think that works. Anything further? Okay, let's go to 7. We have a few minutes left. Anything on 7? Hi.
Nope, I'm always so good at lowering my hand.
It's okay.
No, not then.
All right. Okay. All right, we'll move to 8. Bill?
Should agencies always provide members of the public the opportunity to observe open adjudicative proceedings remotely? I mean, it seems to me that, I mean, if you have a court, a judicial court, there's no requirement that, that they provide remote access to a judicial proceeding. Why should you require agency proceedings to be accessed remotely if it's a live proceeding?
Okay.
I think it depends on what the objective of public access to, and that's sort of going back to that. In some cases, it is to facilitate broad forms of public participation or to ensure that specific communities are able to observe a proceeding. In other cases, it's a disability proceeding.
I accept that. I'm not saying they should never do it.
Right.
All right. But what I'm saying here it is required in all cases.
To the extent feasible.
To the extent feasible. Or
well, I don't even know if that's right. It's where it serves a legitimate public purpose.
Can I jump in on this, or?
Let's go ahead, Jack, and then hi.
I would just say that I think Bill raises a legitimate point. I would just say agencies should consider providing members of the public. Because he's right. I mean, it's, I don't think it's an obligation to provide remote access to an otherwise open hearing.
Hi.
So I would push back on that and stick with the original. Obviously, none of this is going to be a requirement. Again, I'm going back to what are we trying to achieve with this? I think what we're trying to achieve is moving things forward at some agencies. I think we should say from our perspective, from ACUS, once you're going to have an open, you've decided you're going to have an open adjudicative proceeding. We're now saying, and we can refer back to our whole, piece on remote hearings and all, that you should also provide the opportunity for folks to see this remotely, because that especially is important for people with disabilities or different other, socioeconomic limitations in terms of getting to places. So I think we should say agencies should provide members. That's our recommendation. And some of them won't. They just won't because they don't have the money. They don't have, but I'm always looking to have this recommendation be leverage for someone inside an agency that wants the agency to spend some money on this, which would make it so much more transparent. I mean, that's why we're all in this, right? We want it to be more transparent. So I understand the concern, Bill and Jack, and I think that can be referenced. It may not be feasible, but this is what we think is a best practice.
Well, I just have to say, I don't even think it's the best practice in all cases. If you're really talking about making a nationwide hearing for every individual immigration proceeding, right? Which is what you're doing. Because an immigration proceeding will have an evidentiary hearing, and every one of them will have to be made nationally available all over the country to everybody in the country. And it's not just a matter of dollars. It's a question of trying to arrange for that, trying to deal with that for each immigration judge. I just think it's outrageous to think that everybody in the country should be able to sit in on an individual immigration hearing. There's clearly, and I don't think when Jeremy was talking about the objectives of having open access, it was having open access to a wide variety of people all across the country for FCC hearings or FTC hearings. Something that has real nationwide importance is going to affect a lot of people. But we're talking about an individual being deported or an individual being granted asylum, for heaven's sake. Every asylum case is going to be broadcast nationally. I think that's outrageous. I'm sorry.
No, that's a very good point. That's a very good point. I was just reacting again, sort of saying, if feasible, right? Because I'm not sure, you're really talking about something different than just feasibility, which I think is a lot more, definitely has merit. And then the question is whether you're going to capture what you're trying to capture by saying with, the suggestion should consider providing. I just think okay, this is tough because I think should consider providing might be less strong than we want to convey. So I don't have an answer, but.
Roxanne, do you have some thoughts there?
I think that should consider is actually moving things forward. For example, at my agency, the NLRB, we are currently mulling over how do we leverage, if we do it all, the remote aspect of our hearings going forward. We've never in the past provided remote access to hearings that are conducted in person. And reading this, I was like, we haven't thought about this at all. And I don't know that we would have thought about this. And so I think even if we say agencies should consider providing, that is pushing in a direction that we haven't really been pushed before. And I have the same reservation about the should, because if it said should, I would be concerned that we are somehow doing something wrong if we decide not to go down that path, or for whatever reason. So I think we are more behind than you think we are. So should consider is actually a good thing.
Let's put in should consider providing, and we can. Hi, did you have one closing thought?
I just wanted to raise my hand to say I'm fine with should consider providing.
Okay. Thank you, Roxanne.
I'd like to make one further thing. Should consider when it would serve the public interest, the general public interest. In other words, this is something broader than just the parties who are presumably going to be there in person. It's a question of, is this something that ought to be available to people generally? It's
Well,
a
and those-
limitation on just should consider, but it's also a suggestion as what they should be considering when they consider it.
Mhm.
Well, in those situations, they should do it to the extent feasible.
I don't have any problem with it to extent feasible either, but I think you ought to give some guidance as to what, you know, what you should be considering. Feasibility is fine too.
There's two kinds of public interest, though. There's the public interest in the big, you know, headline making hearings that everybody knows about. That's a different kind of public interest than the one that's embodied in this, which is presumptively hearings should be open. You know, they should be open. You should have access to them. Now that runs into the very, you know, cogent objection you made to making every removal hearing available over the country, which is ludicrous. But the presumption here is in favor of openness, and if that's the case, then the presumption is in favor of making it available by whatever means possible. And then the question is how you put in a limitation that doesn't create a barn door for everyone to walk through.
And I would say there are different ways to structure remote access. In some schemes, it's I'm live streaming this on YouTube and anybody can log in and watch.
Right.
In other cases, it's somebody says, I would like to attend this proceeding, but I cannot go to the specific hearing room. Can I have a dial-in number to listen to it?
That would be a great separate section or a different section. I mean, I think that's entirely appropriate, all right?
Mhm.
Even for a removal proceeding, all right?
Yeah.
Maybe a relative who's not able to get there, and they ought to be able
Exactly.
to attend that.
Yep.
I will propose that we are not going to resolve this in the next minute. So we will come back to this one, but all very good points. I should never give you a break. You all come back too energized and ready to go. So, okay.
Can I just suggest one last thing to the authors, I mean, to the drafters, I mean, with respect to section 15, paragraph 15, please consider whether the FACA provision requires more than what we're recommending here now.
We'll do that.
Okay. So our next meeting, I had it here and now I've lost it, is November something. Jeremy.
November 12th.
Thank you. And we will have the rest of the recommendations to look at and the preamble to consider, which I know will be very well done based on all of the things we discussed today. Yes. So it's a wrap for today. I look forward to seeing all of you next time. Thanks as always. Always great discussion. Learn something all the time. Thank you.
Thank you. Bye.
Have a good one.
Nadine.
Thank you.